Start para. The suit is under Section 2 of Dissolution of Muslim Marriages Act 1939 for grant of divorce. As per the contention of plaintiff and defendant are husband and wife, and their marriage was solemnized on 13/5/2003 at Mauze, Nimgaon, as per Muslim rites and customs. Out of their legal wedlock, they have one daughter named Sania. After the marriage, plaintiff started residing with the defendant, and for the first 2 to 3 years they cohabited peacefully. But thereafter, the defendant started ill-treating her, and he drove the defendant out of his house. It is contention of plaintiff that, though having sufficient source of income, defendant is not looking after the plaintiff or their daughter, and due to the physical and mental ill-treatment at the hands of defendants, it is not possible for the plaintiff to cohabit with the defendant. Hence, she has filed present suit for divorce, claiming that the defendant has neglected and failed to provide her maintenance, and defendant has treated her with cruelty. Para. The suit summons was duly served upon the defendant, and after appearance of the defendant, he has admitted the claim of plaintiff in his written statement below Exhibit 11. The defendant has categorically admitted the marriage. He has also submitted on affidavit that he is accepting the claim of plaintiff and shown his willingness to grant divorce to the plaintiff as prayed. Accordingly, as the defendant has not contested the suit and admitted the contentions of the plaintiff, I hereby proceed to pass judgment as per Order 12, Rule 6 of Civil Procedure Code. Order considering the clear admission of the defendant accepting the claim of plaintiff, the summary judgment on admission can be passed below trial. Further, it is well settled principle of law that where the facts are admitted by the parties, there would be no requirement to prove such facts. Purpose of Order 12, Rule 6 of Civil Procedure Code is to avoid the waiting by plaintiff for the decree when there is clear, unequivocal, unambiguous, and unconditional admission of the defendant in respect of the claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent that the admissions of the defendant entitled that relief to the plaintiff. The court must be satisfied that the admission relied upon is clear, unambiguous, definite, and unequivocal. From the statement of the defendant below Exhibit 11, it clearly appears that the admission made by the defendant is clear, unambiguous, definite, and unequivocal, delivered with an intention to be bounded by it. Considering all above, I hereby proceed to pass following order. First, suit is decreed. Second, the marriage solemnized between plaintiff and defendant on 13/5/2003 is hereby dissolved by decree of divorce wide Section 2 of the Dissolution of Muslim Marriages Act, 1939, Marriage Act 1955 from the date of order. Parties to bear their own cost. Decree be drawn up accordingly. Stop.